What looks like a routine probation hearing quickly turns into a dramatic courtroom showdown. A defendant facing multiple probation violations, new criminal charges, and a possible year in jail steps forward with a surprising defense. Serious medical problems, dozens of hospital visits, and a claim that he didn't even realize he was still on probation. But the probation officer paints a completely different picture, saying that for more than a year, the defendant has done absolutely nothing to comply with the court's orders. So who's telling the truth here? Is this a man struggling with genuine medical issues, or someone making excuses after ignoring probation requirements for months? As the judge begins asking tough questions, armed with GPS tracking data and a detailed case history. The situation quickly escalates toward a decision that could change everything. Stay tuned, because what happens next shows exactly how seriously courts take probation violations.
How's the case of the People versus Leo Stringa?
Assistant Public Defender Natalie, Mr. Stringa, who stands to my right. Please state your name for the record, sir.
Leo Stringa.
Thank you, Your Honor. Today's the date and time for, well, 2 cases are set for sentencing and 2 cases are set for violation of probation. I have had the opportunity to review the alleged violations and the recommendations as to the violations of probation with Mr. Stringa. I guess I will start with those first, Your Honor, if Your Honor does not mind.
Go ahead.
We do acknowledge that there are the new criminal convictions and new pending criminal matters. And we do acknowledge that no proof of these things have been sent to probation. Mr. Stringa did indicate to me that he was going to try to get proof of Dawn Farm outpatient treatment. However, unfortunately, I have not received that yet to provide to probation or to the court. We are asking, as far as these cases go, if the court would consider not remanding Mr. Stringa. We do acknowledge that, yes, there are several violations alleged, and there's no getting around that. I'm just asking that the court, if you would consider not imposing the jail time. He does have some significant medical concerns he has been dealing with, and we are just asking if the court would consider not imposing the jail. And we do, as far as this 2 cases set for sentencing, Your Honor, I do not have any material changes to the PSI. As to the recommendation, my request would be similar. I would ask if the court would consider not imposing the jail time.
Stringa, anything you want to, Ms. Polero?
Let's pause here for a moment to understand what's happening legally. When someone is placed on probation, they're essentially being given a second chance instead of serving time in jail. But probation comes with strict requirements. Things like reporting to probation officers, paying fines, attending treatment programs, and staying out of further legal trouble. In this case, the defense attorney openly acknowledges multiple probation violations, which already puts the defendant in a difficult position. Their main strategy here is to ask the judge for mercy based on medical issues and potential treatment options. But judges usually want to see proof of progress. Things like completed treatment, payments made, or documented efforts to comply. Without that, it becomes much harder to convince a court that probation should continue. And the next speaker, the probation officer, is about to explain why they believe jail time is the only option left.
Ms. Polero.
Yeah, sure, Honor. Teresa Polero on behalf of probation. Your Honor, I would just like to make the court aware. It already knows. Mr. Stringa has been on probation for over the last year on the 2 DOP cases. In those cases, he's done nothing. He's not paid 1 cent on either case or record that is owed. That is high amounts on both cases. The only thing that Mr. Stringa has done is picked up new criminal cases. He has convictions. He also has pending matters. I had conversations with Mr. Stringa about getting into treatment. Conversations go that he agrees. He's supposed to be getting his verification. He's doing these things. Probation never receives anything from Mr. Stringa. So those just go on, and he stays in non-compliance. given his past behavior and his continued criminal behavior, probation is asking that the court follow the recommendation for a jail sentence.
Mr. Stringer, anything you want to say?
Yes, Your Honor. As far as my current situation, I've been in and out of the hospital like 32 times. University of Michigan Hospital has cited. I've supplied the court with multiple, documentations of my current medical situation.
This is where the tension in the courtroom really starts to build. The probation officer's statement is blunt. According to their records, the defendant has done nothing for over a year. No payments, no compliance, and even new criminal cases during probation. But now the defendant presents a completely different explanation. He says he's been hospitalized over 30 times, dealing with serious infections and medical complications. If that's true, it could potentially explain why he struggled to comply with probation requirements. However, judges have to evaluate credibility, and that's where evidence like GPS tracking data, hospital records, and probation reports becomes critical. If the defendant claims he couldn't leave the house due to illness, but records show him moving around town, the court will notice that immediately. And that's exactly the line of questioning the judge is about to pursue.
My knee's bleeding through my pants right now. I have osteomyelitis, my bone's infected in my leg. I didn't.
In that regard, and I don't mean to interrupt you, but
Yeah.
in that regard, part of you haven't done any testing, you haven't done anything. Part of your reasoning behind that is basically saying you can't go out in public.
Right, Your Honor.
Well, we have your tracking, and you've been out in public. What were you doing at Briarwood yesterday?
I was trying to apply for a job online that I'm trying to do online. I had to go there and give them some paperwork.
Then why couldn't you go to community corrections?
I could, Your Honor. I don't have any money to pay for it.
Go ahead.
But I am so.
What you want to say?
But I do have a PhD from Michigan, and I am a professor. I was on FMLA from Eastern, but I'm slated to go back. Hopefully, I can do this in January 9th, so I'll be able to create an income. I have been sober. I tried to go to inpatient treatment. They wouldn't let me because of my skin condition. Just to show the court that I was doing something, and I did send some paperwork with that. I don't know if you didn't get it, but okay. Judge Barr's court got it, but yeah, I made a lot of bad choices earlier in my life. I mean, not earlier in my life, earlier with these cases, but I'm on the other side of it as far as me as a person and me continuing to try to do better. I made a mess of the cases, and I didn't know that I was still actually on probation in this case. And it wasn't even really brought to my attention that I wasn't in compliance until I spoke with Ms. Polera maybe 2 months.
Now, the story takes another unexpected turn. The defendant reveals he has a PhD from the University of Michigan and works as a professor. That detail changes the tone of the case because it suggests this isn't someone unfamiliar with systems or paperwork. But it also raises a key question. If someone has that level of education and professional background, how does a probation case spiral this far out of compliance? He also claims he didn't realize he was still on probation and thought the case had already been resolved. That's a risky argument to make in court. Judges typically expect defendants to know their legal obligations, especially when they've been formally sentenced. So now, the judge has two competing narratives in front of him. A defendant asking for another chance, and a probation officer describing a year of non-compliance. While at this point, the judge has to decide whether probation still makes sense, or whether it's time for jail. What do you think about watching this? Should the court give him another chance, or has probation already failed?
Months ago, so I thought I might have had time served on this, but it was another case that it was time served on. But I would just like to give you for you to give me a chance that I can do probation and that I can get through this and make myself a better person. I have so much going on medically right now too. Yeah, I might. Yeah, it's a lot. I don't want to get into it, but I'm at your mercy, Your Honor. I didn't, and this too. It's like, I didn't work so hard my whole life, and get a PhD and do all these things in life to throw it all away. And I want the opportunity to try to do this. And if you give me this chance, I won't prove you wrong.
You were sentenced originally in July 24th of 2024. And now here we are a year plus, almost a year and a half later, and you've done nothing except, as Ms. Blair indicates, is pick up new criminal charges.
Right, I thought
I'm done.
I thought I was time served. I thought the case was over with, Your Honor. I really did. Until I spoke with Ms. Blair 2 months ago, I didn't even know the case was still active. I made a mess, and I had like 4 or 5 retail frauds in Washtenaw County through different 14A, 14B, and 15th. I didn't know which one was which. And when I thought I had time served, I thought it was closed out because nobody told me anything different. And actually, I went to jail, was booked, and let go multiple times, and I never even had a warrant on this case. So I didn't even know that I wasn't in compliance. I didn't even know it existed.
You done?
Yes, sir.
So on the cases ending in 0962 and in 1452, since they have the same recommendation, I'll just do it once. On those, the probation cases, I'm going to revoke your probation. I'm going to sentence you to 365 days in jail, credit 82 days served, defendant to serve the balance. I will waive the remaining terms, accept the financial obligations, discharge you from probation without improvement. I will consider release to Dawn Farm inpatient treatment on those cases.
Thank you, Your Honor.
On the other matters, on the case ending in 0616, $125 statutory fee, 365 days in jail, credit 41 served, defendant to serve the balance. I'll consider release to Dawn Farm inpatient treatment. And on the last case ending in 1677, I'll order $129 statutory fee. I will apply the bond in that case. I'll order 365 days in jail, credit 2 days on that case, defendant to serve the balance. I'll consider release to Dawn Farm inpatient treatment.
Your Honor,
Defendant is remanded.
Your Honor, may I say one thing? Just as far as the inpatient treatment, I have a misdemeanor warrant in another county, which I don't think they'll let me do. Is there any way I could do the Dawn Farms in jail program to get released that way? Is that feasible? Just because I know that you gave me bond conditions before to be released to treatment, and they wouldn't let me go because they said I had a misdemeanor warrant in another county. So I
You consider that another time, but I pronounce my sentence. Defendant remanded.
okay. Thank you, Your Honor. My coat. Thank you.
The judge's decision here sends a clear message about probation. It's an opportunity, but it comes with responsibility. After reviewing the probation officer's report, the new criminal charges, and the lack of compliance over more than a year, the court ultimately revokes probation and imposes 365-day jail sentences across multiple cases, giving credit for time already served. However, the judge still leaves a door open by saying the defendant could be considered for release into inpatient treatment, which suggests the court still sees rehabilitation as possible, but only within a structured environment. This case highlights a bigger reality in the justice system. Probation works only when people actively participate in it. Without compliance, courts often feel they have no choice but to enforce the original penalties. Now, we want to hear from you. Do you think the judge made the right call here? Or should the defendant have been given another chance considering his medical claims? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.